Welcome to the HR Empowerment Podcast, where we will uncover strategies and new insights from HR professionals who discuss up-to-date regulations, best practices, and the most pressing topics like diversity and equity, leadership, dealing with difficult situations, and much more that affect your bottom line and business. Thanks for joining us.
Hi, everybody. Wendy Sellers here, the HR lady. Listen, we're here today to talk about a very serious topic, which is the recent decision of the Supreme Court to overturn Roe versus Wade regarding abortion and abortion rights and access in the United States. It's not an easy topic to talk about, no matter what your opinions are personally. However, this does affect the workplace because we have humans in the workplace, and these humans have their own personal opinions on the topic of abortion and on the recent Supreme Court decision. So what I want to go over in this podcast is how to have these conversations at work, right? We usually say, oh, just don't have these conversations. But let's face it, it's not going to happen. And people have the right to have these conversations. And there's a lot of laws that, even though this, the court overturned the law about abortion and hands back the rulings or the legalities, I should say, to the states, what's really happening, what we're finding out is many states are making laws that are incredibly strict and affect people's lives. Again, not here to discuss either way if you're pro, for, anything like that. But what I want you to know is, as an HR professional, as a manager, as a leader, as a business professional, but definitely if you're managing others and or in human resources, there are laws that you need to be aware of, because even though abortion on a federal level, it's not that it's illegal, and that's what a lot of people think. Oh, it's now illegal. It's like, no, it's just not handled on the federal level. The states are handling it. But these conversations are protected under many, many discrimination laws. And that's the first thing I want to go over, so that we can then get to the rest of like, okay, now what? So I probably would be here for days talking about this, because there are so many laws, as we know, on the federal level than in every single state and territory as well. So please walk away from this conversation today, taking some notes and saying, oh, wait, I have employees in maybe 5 states. Now I need to go to each one of those states and look up the state discrimination laws that are above and beyond the laws of federal. So first thing that you need to know is National Labor Relations Act. So this is generally a law. It's a federal law, but a lot of people think that it is only for organizations with unions, and that's actually not the case at all. So the National Labor Relations Act is going to come into place when your employees may have questions about abortion access, money related to abortions, things like that. They may come to you either in a committee form, individually, an email, a town hall session, a break room conversation where they say something like, hey, we should do something. We should pay for travel for abortion because our state that we live in is banning it. And so I think we should, as a company, have a benefit to pay for travel, or we need to make sure that all employees know where they can get access, or need to know, how safe it is beyond X amount of weeks. Any of these types of conversations may be protected by the National Labor Relations Act, the NLRA. This protects employees' rights, even those without a union, to engage what is called protected concerted activities. So anything related to pay or benefits period. And in this case, we're connecting it to benefits of getting an abortion or receiving information about abortion, or even if they're the anti-abortion, they're saying, no, we don't want you to be advertising this. These should be going ding, 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 ding. I need to be careful how I answer these questions. And hopefully you're walking away from today saying, you know what, I need to get my managers together, my supervisors, and even my team leads, and I need to give them a quick training on what they can and cannot say and how it affects us. So that is the biggest thing that you definitely want to, be concerned about. We're going to be doing, I'm going to be doing webinars as well, and similar to this podcast. So I encourage you to attend that. And then, of course, ask me questions. I don't have all the answers. I'm probably just like you, getting on LinkedIn and all the lawyers' websites, and I am stuck like glue to their advice because things are literally changing by the day. I'll give you an example. I live in the state of Florida, and we do have so since, Roe and Wade was overturned, we've already had in place a law here about abortion after 24 weeks. And I believe it was yesterday, the law was supposed to go into place of saying, okay, you can't have an abortion after 15 weeks, but it was overturned in the court system in Florida. So now it's back to 24 weeks. But, if we weren't glued to our TVs and all of our news feeds, we may not have known that. And so you have to know what does that mean for my example, for my Florida employees, but then all the other companies as well. So number one law that you want to be concerned about right off the bat is just about the chatter, the talk, the conversations about benefits and, total compensation. So in this case, benefits, access to abortions, protected by National Labor Relations Act for not just companies with unions, but companies without unions too. So that's a big one right there. There are a bunch of other laws that employees are also entitled to have conversations about abortion, and then even regardless of what you or your company's overall standpoint is on abortion, they have the rights to still receive an abortion, even if your state has banned it completely. And under Title VII of the Civil Rights Act of 1964, this actually, as you probably know, it bans employment discrimination in all aspects of employment. So from the interview process to retirement and promotions and keeping their job and taking leave and things like that. It's, the Title VII of the Civil Rights Act is based on color, national origin, race, religion, and sex. And sex is very specific that it says including pregnancy. And so including pregnancy is actually related to including abortion as well. So national federal law protects employees with those rights. So you want to make sure that if these conversations are coming up in the workplace, an employee is coming to you, or there's conversations about, hey, I may need an abortion, or somebody in the organization may need an abortion, or somebody in my family may need an abortion. What are our policies? What are our rights? Just remember that that's, again, a discriminatory conversation that you need to be careful of, because you cannot make a decision on somebody's employment or their role or a promotion or lack of promotion based off of sex, which includes pregnancy and abortion. So be super, super careful. Make sure all your team leads, supervisors know, hey, if there's any of these conversations, there should be a radar up that like, okay, I need to proceed with caution, and I probably need to go back to whoever's listening to this today, my HR person, if there is an HR person, or somebody who's acting as HR, to say, what the heck do I do right now? Because this is first of all, very personal and delicate conversation, but then on top of that, we may be unintentionally breaking laws depending on how we're answering this conversation. So you cannot, again, make any employment decisions based on that, no matter what your personal feelings are. It does not matter.
Thank you for joining the HR Empowerment Podcast, brought to you by Aurora Training Advantage. We hope you've gained new insight and strategies to navigate the HR profession. We look forward to you joining us again on the HR Empowerment Podcast.